The Migrant Workers Convention was adopted in 1990 and entered into force in July 2003. To date, only 46 countries have ratified the convention. Most of these are countries of origin for migrant workers. Indonesia ratified the convention in 2012 and will make its first report to the Committee on Migrant Workers in 2013.
Hi, my name's Paddy Vellies.
And I'm Simon Cook.
We're students at the University of New South Wales Human Rights Clinic. As Indonesia prepares to review its laws on migrant workers, we've been asked to provide advice about the key obligations under the Migrant Workers Convention. Today we'll provide an overview of the Convention, focusing mainly on the obligations for countries of origin and specifically Indonesia. We will cover 5 thematic areas and conclude with the key obligations for Indonesia and other countries signatory to the Convention.
This presentation is based on a longer legal analysis we provided in a letter to Indonesian civil society organisations, and includes comments and interpretation by the Committee on the Protection of the Rights of All Migrant Workers and Their Families.
The Convention applies to the entire migration process of migrant workers and their families, from pre-departure to return. It defines a migrant worker as a person who is to be engaged, is engaged or has been engaged in a remunerated activity in a state of which he or she is not a national. The Convention sets out fundamental rights relevant to migrant workers and migrant labour.
It incorporates the fundamental rights contained in the International Convention on Civil and Political Rights, the International Convention on Social, Cultural and Economic Rights, the Convention on the Elimination of Discrimination Against Women, and other international treaties. The Convention is important because it protects all migrant workers, even those without legal status. Also, the Convention sets out both fundamental rights common to all people, as well as rights specific to migrant workers and their families. Finally, the Convention tells governments what they must do to have a safe and fair labour migration system.
In the pre-departure phase, governments are responsible for ensuring that migrant workers are informed and have access to a fair and just recruitment procedure. A primary obligation of origin countries is to ensure that individuals considering migrating for work and migrant workers are adequately informed about the rights and responsibilities before departure.
Articles 33 and 37 of the Migrant Workers Convention establish rights to information for migrant workers and their families. Article 65.1 requires countries of origin to provide information services for prospective or current migrant workers and members of their families about international migration. To comply with these obligations, countries of origin must 1. Prepare and provide information specific to each destination country and general information about the rights of migrant workers. 2. Make information available free of cost to anyone considering migrating for work. And 3. Provide specific information to prospective migrant workers preparing to depart about the specific destination country.
Governments should use a variety of methods to distribute this information.
The Committee on the Protection of the Rights of All Migrant Workers and Their Families has suggested pre-departure training also include language training, job skill training and cross-cultural training. Information and training should be of high quality, practically accessible and available free of cost. The effectiveness of training should be evaluated regularly.
Information and training is usually provided during the recruitment process. The origin country government is also responsible for regulating the recruitment system and private recruiters. However, Article 66 sets out standards for recruitment agents. They must be limited to government-run agencies or private agencies that are authorised, approved and monitored by government authorities. Therefore, they should not include individual brokers. The Committee on Migrant Workers explains that states have an obligation to effectively regulate and monitor private agencies to ensure that they respect the rights of migrant workers. Simply enacting regulations is not enough to satisfy this obligation. It must be effective. The committee suggests formal, regular, transparent and state-regulated mechanisms that cover licensing, monitoring, inspecting and evaluating recruitment agencies, imposing sanctions and penalties, and establishing systems of recording and reporting that are easily accessible to the public. The committee further states that regulation and monitoring of recruitment agencies should be focused on the rights of domestic workers, including rules governing fees and salary deductions and penalties for violation. Government should work with civil society organisations, workers and employers in developing criteria for licensing. According to the committee, the government must prevent, investigate and punish private recruitment agencies that prevent migrant workers from holding their travel and identity documents at all times. It is stated that government should also ensure that migrant domestic workers have explicit, written contracts in a language they can understand.
While the migrant worker is abroad, the country of origin continues to have some obligation to support and protect its citizens. This is done through embassies and allows migrant workers to send home their earnings as remittances. Articles 16 and 23 create rights for migrant workers to communicate with consular or diplomatic authorities if arrested, and to access assistance from these diplomatic authorities.
Consulates must also provide adequate services that are necessary to meet the social, cultural and other needs of migrant workers and members of their families. The Committee on Migrant Workers encourages countries of origin to provide certain services for migrant domestic workers specifically. This includes legal assistance, support to victims of abuse, data collection and information dissemination, and diplomatic measures.
As an example, embassy and consular officers could provide legal assistance managed by host country lawyers who are knowledgeable about procedures in the destination and employment country.
The committee recommends that states improve accessibility to existing consular services by 1. Increasing the number of officers in host countries, 2. Making programs more visible, and 3. Training and giving sufficient resources to embassy and consular personnel to provide advice, protection and assistance to migrant workers.
When working abroad, most migrant workers receive their salaries in the destination country. Under the Convention, documented and regular migrants have the right to send their earnings home at any time. Countries of employment are required to take measures to facilitate this transfer. For undocumented migrants, the right is only to transfer their savings, earnings and personal property at the end of their stay.
The Committee on Migrant Workers has recommended that states establish formal channels for migrant workers to transmit funds in order to minimise transaction costs often incurred through the use of informal channels. They also recommend a diverse range of channels.
Article 8.2 of the Convention states that all migrant workers have a right to return to their country of citizenship. Governments must adopt measures for the orderly return of migrant workers and their families. Programs that contribute to an orderly return include 1. Placing the onus on recruiters to provide return airfares to migrant workers under their employment contracts, and 2. Providing for the return of migrant workers' belongings. After they have returned, the Convention requires the country of destination and origin to cooperate to facilitate the social and economic reintegration of workers in their home communities. The committee has explained that this obligation has two components. 1. Support to economically and socially reintegrate migrant workers, And 2. Ensure workers have the ability to pursue claims for violations that occurred abroad. States are obligated to provide migrant workers with an effective remedy if any of their convention rights are violated, even if by a government official. The Convention does not provide details of what makes a remedy effective. However, the Human Rights Committee, in relation to a similar provision in the ICCPR, has stated that states must 1. Establish accessible remedies under domestic law through which migrant workers can make claims for violation of their rights and have those claims properly adjudicated. 2. Ensure migrant workers have access to effective remedies, which usually includes compensation but may include other forms of reparation. 3. Ensure state enforcement of remedies. 4. Investigate allegations of violations. 5. Take measures to ensure violations do not recur. And 6. Inform migrant workers of the above rights.
In summary, the key obligations that should be incorporated include 1. Guarantee of fair and equal treatment for women and men migrant workers in any law on the placement and protection of all migrant workers. 2. Effective provision of pre-departure information and training to all prospective and current migrant workers, free of cost and in a language, location and with content relevant to the specific needs of the migrant worker and their families, to be developed in partnership with civil society organisations, migrant domestic workers and their families, and reliable recruitment agencies.
3. Effectively regulate and monitor private recruitment agencies and brokers. 4. Guarantee a worker's right to keep her identity documents. 5. Require explicit written contracts for all migrant workers in a language they can understand. 6. Provide consular and other services in the country of destination. 7. Provide a clear and accessible complaint procedure and effective remedies for rights violations. 8. Establish affordable remittance systems.
9. Establish orderly return procedures for all migrant workers. 10. Provide social and economic reintegration support. And 11. Investigate allegations of convention rights violations and adopt measures to ensure that violations do not reoccur. Thank you for viewing our presentation. For further information or inquiries, please refer to the Human Rights Clinic website.